What did Jeremy Hogan say about XRP? What are the recent updates on the lawsuit? Is the Ripple vs. SEC lawsuit nearing its end? If you want to learn all about it and more, then keep watching this video to find out more so that you don't miss out on an excellent opportunity to win a giveaway of 50 XRP tokens at the end of this month. Hello guys, welcome to Whiteboard Crypto Update, the #1 YouTube channel for crypto education. In today's video, we will talk about XRP's future, so be sure to stay focused as you surely don't want to miss out on this. If you are new to the channel, be sure to subscribe to the channel and turn on post notifications by hitting the bell so you never miss any of our uploads and also enter our giveaway. XRP is the asset of the XRP ledger blockchain. Throughout the crypto industry, participants sometimes refer to the XRP coin as Ripple or as the same thing. According to Ripple, XRP and its underlying XRPL blockchain are separate from the technology which is focused on improving the payments landscape worldwide. Ripple does, however, utilize XRP and the XRPL in some of its solutions. XRP is a borderless coin running on the open-source XRP ledger blockchain. The asset was constructed as a solution to improve payments across the world. Companies or platforms can incorporate the asset into their processes or use the coin itself, while individuals can also send and receive XRP. 2021 was a real roller coaster, especially for XRP holders, as the SEC versus Ripple litigation took multiple twists and turns throughout the year. While the SEC's bias aggravated the XRP community, the community also received worldwide support, ultimately making the XRP lawsuit one of the most historical cases in the decentralized industry. In December 2020, regulatory uncertainties surfaced regarding Ripple. According to a complaint made by the United States Securities and Exchange Commission, Ripple sold XRP to investors in the US and the global public as part of an unregistered securities sale that garnered over $1.3 billion. Since the cryptocurrency industry is new compared with traditional finance, the regulatory status of crypto assets has surfaced as a topic of discussion over the years. The Commodity Futures Trading Commission has expressed a view of Bitcoin and Ethereum as commodities, although classification has been foggier for other digital assets. As per the SEC's movement against Ripple, the Commission alleged XRP to be a security, which would fall under the SEC's jurisdiction. A petition came forward from a group of people that bought XRP, citing arguments for XRP's classification as something other than a security. Ripple has argued that the SEC's action came too long after the creation of XRP, and that other U.S. government agencies have given XRP a classification other than that of security. After several winning rounds for Ripple, the SEC is back, putting pressure in the form of the motion to compel Ripple to hand over recordings that will support the agency's case that XRP was marketed as security. While the dispute over the tapes continues and the judge's decision is still pending, attorney Jeremy Hogan went on YouTube to explore how Ripple can lose the lawsuit and what it means for XRP. Mr. Hogan pointed to two scenarios that can lead the SEC to victory. The marketing scenario is like Telegram developing the blockchain project Gram. The SEC wants to show the court to conclude that a reasonable purchaser of XRP would expect a profit from Ripple's continued support of XRP. The SEC has already found evidence that proves its case. One example provided by attorney Hogan is Ripple's CTO David Schwartz's comment in 2013. As a corporation, we are legally obligated to maximize shareholder value. With our current business model, that means acting to increase the value and liquidity of XRP. That is one path to victory for the SEC. But it is not the worst case scenario because the marketing path does not focus on anything inherent to XRP itself, just how Ripple sold it. This first scenario would be limited to disgorgement damages and perhaps injunctive relief. But could it amount to a finding that XRP is inherently a security? The attorney asked. Jeremy Hogan raised two questions for the scenario where Ripple loses the lawsuit. 1. Can Ripple continue its business after paying the disgorgement judgment without potentially being able to sell XRP, except to perhaps accredited investors? 2. Will the exchanges feel confident enough to relist XRP? The second scenario, which disputes the inherent nature of XRP, raises even more complex questions. Attorney Jeremy Hogan called it the tidal wave scenario, and it hinges on what is currently going on in the litigation with expert discovery. The bigger concern is based on the decentralization, or lack thereof, of the XRP ledger. The SEC hasn't focused on this argument, probably because it is a losing argument and doesn't mesh with its case theory. But it is much more dangerous to you, he continued, stating that the argument here is that XRP is centralized and so reliant on Ripple that it makes it a security. There has never been a crypto case in which this has happened. So, this would be uncharted waters, but any order's effect would be devastating, would have an instantaneous chilling effect on the markets, freezing liquidity, and leaving XRP holders holding the bag. Now more recently, the Securities and Exchange Commission has filed a letter of supplemental authority in support of its motion to strike Ripple's fourth affirmative defense, the fair notice argument. The plaintiff had brought to the court of the 20th of December 2021 ruling on a Northern District of Illinois court denying the defendant's motion to dismiss the SEC versus 5. According to the letter, the 5 defendants contended they did not have fair notice of the SEC's novel interpretation of the statutory term dealer. The court stood by the SEC as it agreed that for purposes of assessing fair notice and due process, the standard against which the SEC seeks to measure defendants' conduct is the statute itself, the language of which defendants and all others even arguably involved in securities transactions have had notice. The SEC is looking to make the same argument in the SEC versus Ripple. It is for the courts, not the parties, to determine whether particular conduct falls within the scope of the statute. Indeed, the court rejected the defendant's fair notice defense at the motion to dismiss stage despite acknowledging that lack of binding authority constructing the term dealer. In Ripple's case, binding authority constructing the term investment contract has existed since 1946. While Ripple Labs prepares a reply to the SEC's letter, XRP community attorney Jeremy Hogan took to Twitter to offer its analysis on that case, which marginally helps the SEC's position in its motion to strike Ripple's fair notice defense. It was in a very different stage of the litigation, and the standard is completely different than the SEC versus Ripple case, he said. In the 5 case, the defendant tried to argue fair notice to dismiss the lawsuit entirely and then failed because the burden is very high on a party moving to strike a pleading. 5 can still raise it as an affirmative defense later, and I expect they will. In the Ripple case, it's the SEC that is trying to strike the affirmative defense of fair notice, and it has the high burden to meet. The general idea in modern courts is that the decision should be made after looking at the evidence unless there's no plausible way of winning, Attorney Hogan explained. Luckily, this long-standing feud between distributed ledger technology firm Ripple and the United States Securities and Exchange Commission is nearing its end. According to Ripple's CEO, Brad Garlinhouse highlighted the progress made in the case despite a slow-moving judicial process. Speaking to CNBC, he predicted that the Ripple case would likely conclude in 2022. "We're seeing good questions asked by the judge," Garlinhouse said, adding his belief that the judge realizes this is not just about Ripple. This will have broader implications. Last year, the SEC charged Ripple with allegations of selling unlicensed securities in the form of XRP tokens since 2013. Ripple objected to the claims, saying that XRP should not be considered a security. The SEC claimed Ripple could have been aware that XRP could be secured from its legal advisors before moving forward with its token sale and filed a motion to access defendants' legal advice. The court denied the motion, citing the attorney-client privilege. Over the year, Ripple executives shared insights on the case and its impact on business. Garlinhouse stated that the SEC lawsuit undamaged Ripple's expansion to the Asia-Pacific region. The company is also looking at a possible initial public offering when the case is settled. Support arrived from XRP token holders, who filed Friends of the Court briefs, which would allow them to join the case as defendants and support Ripple in its claims that the token does not violate securities laws. However, the judge ruled in October that individual XRP holders cannot act in Ripple's ongoing lawsuit as defendants. Well, guys, that's all we have for you today. What are your thoughts on this? Get involved and let us know in the comments down below. If you guys like this video, then be sure to give this video a big thumbs up. Also, if you don't want to miss out on any new future videos, then be sure to click on the subscribe button and turn on the notification under this video so that you're notified the next time we upload a video on the latest crypto and cryptocurrency news. Until the next video comes out, you can watch our other videos about XRP or other cryptocurrencies. Thank you for watching, and we will see you again in the next video. Goodbye.